Hello everyone, welcome to our webinar. I'm Lisa Harker, I'm Director of the Nuffield Family Justice Observatory. We're here today to talk about the family justice system of the future. It's an opportunity to reflect on how this system, which makes life-changing decisions about tens of thousands of children every year, could work better for children and their families. Now, over 1,000 of you signed up to join this event, and we're pleased to welcome a really wide range of people, including solicitors, barristers, mediators, magistrates, midwives, judges, guardians, family court advisors, academics, social workers, parents, and policymakers from Westminster and the Welsh Government, just to name a few. You're all very welcome. We're pleased to see that there's a strong appetite to be part of this conversation, and we know that the family justice system is full of committed and dedicated people passionate about improving the lives of children and families. Now, cast your mind back 15 years to 2011. Sir David Norgrove led a review of the family justice system on behalf of the government. He said he found, and I quote, "a system that is not a system, characterised by mutual distrust and a lack of leadership, by incoherence and without solid evidence-based knowledge about how it really works." So, 15 years on, how would you describe the family justice system today in just one word? Unified? Fragmented? Compassionate? Chaotic? What word springs to mind? We'd like to hear from you. So if you could scan the QR code that's on the screen or click on the link in the chat, submit your answer via Menti and let us know what you think. Whilst you're doing that, I'm going to run through today's programme with you. We're here until 6 p.m. First up this afternoon, we will hear from a group of young people who have had experience of the family justice system. We brought these young people together to help us at Nuffield Family Justice Observatory with the development of our new strategy. What they shared with us was so powerful that we wanted to show it to you today. Following this, I'm pleased that Jackie Tiotto, Chief Executive of CAFCAS, is joining us to talk about why children need to guide our thinking. The government is currently preparing a strategy for the family justice system. So we'll be hearing from Josh McAllister, Minister for Children and Families, about some of the themes to expect in this strategy. And then we're going to hear from a wide range of people who work across the family justice system and from parents with lived experience of the system, who will each share their hopes for the family justice system of the future. Finally, we have a fantastic panel joining me to reflect on everything that we've heard. Now, throughout the webinar, we're going to ask for your input. We're going to be using Menti to get your views, and of course, you're welcome to add questions and comments in the chat. These will all be read by the Nuffield Family Justice Observatory team, and this will help to shape future research and events. We'll also follow up to any specific questions or feedback after the event. If you much prefer to watch the event without the potential distraction of chat, you can disable it by unchecking Show Chat Preview in the Chat tab and by keeping the chat window closed. Finally, we're recording this webinar and some of the content will be available afterwards on the events section of our website. You'll also find recordings of other events there too. Okay, so before we kick off, let's have a look at your descriptions of the family justice system today. Wow, it's interesting to see fragmented, broken, inconsistent, chaotic, struggling, challenging, unjust. Those are the big words that are coming out in this word cloud. Disorganised, outdated. Yeah, so pretty negative feelings about where we're starting from and a sense of a system that is really under huge pressure. Okay, let's turn to our first contributors, a group of young people who shared their experiences of the family justice system. This is what they had to say.
Don't really know anything about with the court or anything like that because I was made to sit out in a car park. So the communication there wasn't good, but that's about all I know. I just was sat outside.
It's like they were writing things down, but they like weren't really asking how I was doing and how I felt about it. They were asking the questions that they were supposed to ask, right? But they, as I said, they weren't asking about my mental health and well-being and like how I thought about the situation. So I felt like I wasn't really included. And when it came to the court hearing and stuff like that, me and my sister weren't allowed to attend. I don't know why, but it was just the judge and my mum and my dad. I don't know why I wasn't allowed to go, but I didn't really question it. I felt ignored and like I didn't feel like I was heard as much as I wanted to be. I felt like I also wanted to be in the court meetings as well because I could have said some things that could have kind of changed how it all came out because I didn't stop like my parents from going back and forward. And like I went from my dad's house back to my mom's, like kept on going and going and going. So
To this day, I still don't know what happened in that room. I haven't been informed, but I just know it wasn't anything good.
Should be able to give like young people more of a like chance to like express what they want and how they feel.
You are just like a case and you're one of thousands. It's like you're a number on a piece of paper, that your feelings aren't really taken into account. They just see the case and they see what needs to be done and what boxes need to be ticked. You're no longer a person.
like everyone should be included. Like the social workers could be more focused on the child's mental health and well-being instead of just like as in like asking questions about your living situation. Like yes, that's also compulsory, but you should also be asking how that child is, how they feel and how you could help them instead of just, and like I don't really know what else, but like also like making sure that everybody knows that their opinions have been taken to accountability.
They could like ask the child first if they wanted to be involved or not, and then act on their response.
Thank you to every one of those young people for sharing their experiences. I think you'll agree it's not an easy watch, and that comment of having to sit in the car park while decisions are made about with you, that's really stayed with me. It's also so striking that every one of those young people did not feel that they had been truly heard by a system that is about meeting their needs. Now, it's your turn to share your views. What do children and families need from the family justice system? We want to hear from you. Please share one or two words about what you think children and families need. Use the Menti code there on your screen. And while you're thinking and submitting your answers, let me share some of the responses we received to the question we posed when you first registered for this event. We asked you your hopes for the system in 2030. Now, I'm not going to be able to do justice to all the hundreds of comments that we've received, but we have read them all. And a lot of you talked about your hope that the system would be more child-centred. And fairness was a common theme. For example, you said that you hope the system would be faster, fairer, and truly centred on the needs of children, more trauma-informed for the families we work with. Transparent, fair, and equitable, and open to reform. And I was particularly struck by the way some professionals talked about services beyond their own remit, reflecting the fact that we are dependent on one another to achieve change. For example, a magistrate said they would like to see better outcomes for children with much greater resources for CAFCAS and the specialist services children need. Someone working in children's services asked, I'm wondering what learning can be gathered from the family drug and alcohol court and how we can replicate those ways of working on a wider scale across family courts. Also, some of you talked about the need for better alignment. In particular, several people commented on the need for the family justice system to be aligned with the Family First partnership reforms currently being implemented in children's social care. And a judge spoke about wanting to work in partnership, focusing on solutions, not conflict. So a real focus on working together to achieve change. So let's take a look at the results of the Menti poll. So we asked you, what do children and families need? They need, you can see from the results, they need understanding, honesty, fairness, transparency, compassion, to feel heard, consistency, empathy, clarity, safety, listening, trauma-informed. Very, very similar sort of sets of words there, all around the child being properly heard, and for there to be fairness in the system. I think you're reflecting that back in those words too. Well, I'm now delighted to welcome Jackie Tiotto to give our keynote address. As the Chief Executive of the public body that represents children in family court cases, she's perfectly placed to set out why children need to guide our thinking.
Thank you, Lisa, and thank you to everybody who's watching and taking part in this webinar today. Thank you also for inviting me to ask what in fact is a question I think we need to ask ourselves daily, whoever we are, parent, professional, in family justice, which is why children should guide our thinking. And I've got about 10 minutes, I think, to try and help us to think about that together. And what I want to do is just ask us a question at the start of this presentation that perhaps we can speak about a little bit later, and in doing so, setting out the context for CAFCAS just a little bit. I wanted to talk a bit about the family court in 2030, and when I was thinking about doing that, I wanted to be honest about what children would say about the family court in 2030, and I asked some children, some members of our fantastic Family Justice Young People's Board, and what they told me just absolutely blew my mind, and is the context of some of the principles that I think we need to think about if we really are going to have child-led family justice in the future. And part of that will take us to what we might want to prioritise as adults and professionals working in the system and trying to solve some of the difficulties that children find themselves in when they're faced being part of family court proceedings. So just a bit of context about who these children are. There are 12 million children, as most of you will know, in the population in the UK. They represent about 20% of the total population. And CAFCAS works with about 92,000 new children every year in either public or private law proceedings. And that is split by about 1/3 of those children, so something in the order of 28,000 come to the family court in public law proceedings, and about 64,000 in private law proceedings. And I'm sure if you're on this webinar, you know what that means, but if there are young people or people new to the business on the webinar, that would mean that in public law proceedings, a local authority has had concerns about the safety and protection of that child in their family home, and therefore the court is asked to consider the risk and harm that those children live with and have experienced either now or in the future. And in private law proceedings, when families separate and can't agree on the arrangements for their children, they can apply to the family court for that decision to be made in the family proceedings court. And that is the private law proceedings I'm referring to. So 2/3 of our work relates to private law proceedings. And overall, we are talking today about less than 1% of the general population of children. And the question I want to ask really is about how well we can do by those children. So if we catapult ourselves forward 5 years, I will have been leading an organisation, hopefully, that will have seen another close to 500,000 children. If the statistics remain the same, and they have done for some time, about 40% of those children in public law proceedings will be under 5, and 20% of them will be under 2, will be infants. And about 70% of children in private law proceedings are under 10. And the reason I put those numbers to you is because we're talking about very young children in a lot of these difficult circumstances where adults are being asked to make decisions, give advice to the court. And we have got less than 1% of the child population to work this through with, and I think we can and should be inspired to do more. And the reason for that is because all of those children, that 0.75 of the population that they are, will have lived with abuse and neglect. If they are in public law proceedings, that will have been known about. That's why they're in public law proceedings. And if they're in private law proceedings before, during and after the separation of their parents, they may well have been living with domestic abuse, family conflict, emotional harm that goes on. And so we have to do something that is being guided by what they say. So in advance of today, I asked an adult in the profession that we are in the system that we're in, what would you design as a family court for the future? And you can see there a lovely building with a cafe, a library, some soft seating, a quiet space, a room for the judges, a TV room, a games room. Wouldn't that be lovely? But actually the adult focused, and I make no judgment, on the structure and the process that would go on in the court. And when I asked Aidan and Milo, two members of our Family Justice Young People's Board, this picture is what they drew. And I want to just expose some of the things that they wrote that are important, but which illustrate that what children want to optimise in the system that we live in family justice is their lived experience. That's what they want to shine. So within that picture, and I won't read all of the words that they have written word for word, but they describe a box needing to be in the courtroom. Why do they describe a box? They talk about a box with things in there that will help children if they feel anxious. And those children are going for a principle of emotional safety being important in the process of family justice. And as adults, we prioritise efficiency more than we prioritise emotional safety. And what I should have said at the start of this little section is I don't present this to you to be critical of what adults do and what children want us to do, but more for effect in terms of the degree of culture change that is going to be needed if we really are a system that's going to be led by children. So the second part of their picture that you will have seen is a chair at the back of the courtroom. And the words they use are, this chair is unique. It makes the child feel special and important. It reminds everyone that the child should be at the centre of proceedings. The chair must be adjustable so that the child is the same height as the judge. Don't you just love that? What they are going for there is that they have genuine influence in the courtroom. And what we do in this current system is we do try and host participation events, which are great. But very often, in my experience and in the experience of some of the people I work with, the voices of the adults in the disputes that we are part of are louder than the voices of the children. Aidan and Milo talked about a rug in the middle of the courtroom with a logo of a child. And they say this logo shows the child is at the heart of everything and everyone else is a piece of jigsaw in their lives. We are a piece of jigsaw. They are the centre. I'm not sure we feel that we are part of a jigsaw. Perhaps we feel that they are. I don't know. But they are looking for children who shape what happens. And we often describe what happens for children when we speak about them. They are rarely in the courtroom and present. They talk about a teddy bear. It's a personal teddy bear. It has a name for the child to choose and they get to keep it at the end of proceedings. And when I said, why have you put a teddy bear into the courtroom? And they said, because we want adults to recognise the emotional journey that this is for us and how important it is to be present in the proceedings. And as adults, we don't really talk about the emotional journey. We talk about case progression. And fifthly, when you stand back and you look at the picture that they drew for me, they say, these are their words, the child sits next to the judge and their advocate. They are raised above everyone else because they are important. Everyone else sits in a circle to show that they are all the same. No one is more important than anyone else. And what you may not be able to see, colleagues, on that slide is that around the circle are the parents and the solicitors for the parents and the CAFCAS officers. The people at the height and the centre of the court are the judge, the child and their advocate. They are absolutely seeking in that principled drawing that children's experiences and safe resolution of conflict is what is at the centre of what happens. And at the moment, we do have an adversarial, instructive system that doesn't do, I think, what Aidan and Milo were going for. And very lastly, they write, the judge, or it could be a family court advisor if it's the same one, visits the child every 2 weeks throughout proceedings. The judge meets the child after the case is finished to check how the child is coping. They are asking us to think about and help them live through the change that we make decisions for. And what we talk about is managing their case. And so to finish, colleagues, if we are guided by children, they will be looking for adults who listen consistently, who think about their emotional safety, who assess. They will be assessing whether we repeat their words or we reinterpret them, whether we help them with things that make sense, whether we are in relationships that are trustworthy with them, whether they're going to be blamed for the conflict or whether they're even invisible to the proceedings themselves. And I think we've heard some video footage this afternoon that some children have felt invisible. If you're sitting in a car park and you're not part of the decision making, you will feel alone and separated from the decisions. So if we are in 2030 and we are being led by children, we would have to do this. We would have to say to ourselves, how does the family justice system feel for those children? Not how is it, how does it feel? What do they say helps them? What do they say harms them or makes sense to them? What makes them safer, and what do they wish that adults understood? And we could make those questions more complicated, but in the end, that is what children seek from us. And I would leave you with a thought from me that is, children aren't harmed by adults disagreeing. They're harmed by disagreement that feels unsafe, goes on forever, is frightening and unpredictable. And they never say, can we have more process? They say, as you've heard, can we have more certainty, more explanation about the decisions that you're making, more honesty and more kindness, not to be left in the car park. Thank you very much.
Thank you so much, Jackie, for inviting us to think really deeply about what children need. And I think we'll return to these questions and this topic in the panel discussion. Jackie's going to join us later in the panel discussion. Now, we seem to be on the cusp of change in the family justice system, and Cafcass and Cafcass Cymru are very much at the forefront of that. Some of you will be familiar with the new child-focused courts that Jackie mentioned, a different way of running private law proceedings, which really foregrounds young people's views and wishes and feelings through a child impact report. I'd like to show you a graph which shows some data from standard private law proceedings in 2019-20. So this predates the new child-focused courts. And it shows that at that point, only around half of children and young people in private law proceedings had some marker of participation, a visit from a Cafcass guardian or a representative of the local authority. Regardless of their age, you can see it's pretty consistent across all age groups. Now, as the child-focused courts start to roll out across the country, we expect this percentage to increase sharply. And at Nuffield Family Justice Observatory, we're calling for the routine collection of data that tells us whether and how children are participating in decisions that are made about them. Change is also on the cards as the government is currently preparing a strategy for the family justice system. So now we turn to the Minister for Children and Families, Josh McAllister. We invited Josh to tell us about what to expect.
The government's priorities for children and families are about breaking down barriers to opportunity at every stage of life that children might experience it. And we know that there are hundreds of thousands of children every year who have families where there's conflict or really acute stress, and children may not be getting the safety, the stability, the love and attention that they need. And we see that for a smaller number of those children, they end up coming into the spotlight of the family justice system. And it's often when families have reached crisis point, when things have become really difficult for those families, and we're waiting for society, through the laws that we've made, to reach some judgments about what needs to be in place for the future of those children. And so it's a reflection, family justice is a reflection of our values as a country, and the decisions that get made when families maybe can't make those decisions for children by themselves. So for me, it's an expression of our values as a country, but it's also a critical part of the whole children's social care system and wider system of support for families that often only gets experienced in the most acute and stressful situations. So we need it to be quick, we need it to be just, and we need it to be well resourced enough to offer the support that goes alongside those judgments as well. The government has not had a family justice strategy for about 15 years, so this has been an area of government policy that hasn't had enough direction previously. We're going to change that, and we're publishing a new family justice strategy between the Ministry of Justice and the Department for Education. And what I'm looking forward to in that plan is setting out the details for how we can have a more transparent family justice system, one in which we're able to give speedier judgments and decisions through family justice. And then finally, I did a review of the whole of the care system before I was elected as an MP, and certainly before I became a government minister, in which I set out the case for a less adversarial family justice system that could learn from the brilliant things that we've seen in family drug and alcohol courts. And so I want to see us bring the learnings from FDACs and other problem-solving courts into the mainstream of the system without losing the need for accountability, the need for real clarity and ultimately some decisions to be made. And I think it is possible to have that less adversarial system that's still able to be just, that's still able to be decisive and timely. And that's essentially the direction that we want the family justice system to go in. 5 years from now, I want the family justice system to be in a place where children and families are not having to wait a long period of time to have the chance for those decisions to be made in the family justice system. We know that it's often a bottleneck in decisions where children might not be safe or where there's disputes between parents, and those delays often add to the uncertainty and the stress for families, but also decisions about stability for children. So I want in 5 years to have a much more timely set of decisions and a system that's set up and confident in dealing with the demand that is there. I also want a system which is more transparent and able to learn. We know that there are very different types of orders being given and granted across the country. We do not know enough about why that difference is there, and I want transparency into the system. I want the daylight to be brought to that variation, so that areas in the country can learn from one another, and so that we can have a more equitable, balanced system about the kind of orders that are being granted. I think we owe that to families, and we owe that to children. And I also want to make sure that alongside everything that we're doing to improve the family justice system, we also have a children's social care system that's fit for purpose, and that is what we're getting on with now. So the government has got a big plan to rebalance support for families to be more intensive before families reach that crisis point or need child protection intervention, and when children do need care, that the obsession of the system is building lifelong loving relationships. So all of this fits together. It's a comprehensive set of plans, and I'm really looking forward to working with everybody in the family justice system in the years to come to make it a reality.
Thank you, Josh. So what do you think the government's vision for the family justice system should be? We asked a range of professionals and parents for their vision for the family justice system in 2030. Here's what they told us.
Hi, I'm Kaylee, and I hope by 2030 the justice system will be making things clearer to parents, learning from lived experiences, helping support families with next or no network or family, giving parents a chance, because all it takes is one person to believe in that person, listening to families' voices, but listen to understand, not respond, because every decision that is made has a domino effect on that family.
My hope is that by 2030, the family justice system will be care aware and trauma informed. I really hope that we start to learn to speak the language of care experience and have more care experience representation and care experience lawyers. We are now mentoring 126 care experience people at Lawyers Who Care, which is a fantastic achievement. And I think the depth of perception that lived experience is so powerful in line with professional experience. And when those two things come together, I feel like we move closer to listening to the voices of children, and particularly care experienced children.
So I hope by 2030, the family justice system will stop holding parents responsible for the societal neglect that by and large denies them the basic conditions that every human being needs to thrive, as well as the care and support they need to parent their children safely at home.
My hope for 2030 will be to see a family justice system that doesn't just think about the needs, the support of Black and global majority children families, but all children families through the lens of, very much thinking through the lens of prevention and change, so that we can also think about improved outcomes. And to do that, we have to make sure that we are seeing, hearing, and really actively listening to the needs of all children, but particularly those that are underrepresented within our system, or overrepresented within our systems in particular. And I think for this to really work, when we're thinking about equity, we cannot think about equity without thinking about how we view difference and thinking about how difference can impact our decision making.
My hope is by 2030, the family justice system will continue to grow in how it listens to the voices of those it supports, not just by asking for feedback, but by taking meaningful steps to reflect and act on it. I hope you see a shift towards giving professionals more time to build genuine, trusting relationships so that children feel better connected in their proceedings and can see how their voice is heard, valued and respected.
My hope is that by 2030, the family justice system will provide many more family drug and alcohol courts to service every single local authority area in the country, because we know that they improve the experiences of children and families, and we also know that they produce far better outcomes for children. I also hope that by 2030 there will be many more judges who look like me.
By 2030, I'd hope that the family justice system is completely neuro-inclusive. This means ensuring that the neurodivergent community has equal access to justice, with professionals working within the family justice and child protection systems having an understanding of neurodivergence and the barriers neurodivergent individuals can face. Together with my colleagues at Flank, we will achieve this by ensuring that all professionals working within the family justice and child protection systems have training in working with and understanding neurodivergent children and adults.
My hope is that by 2030, the family justice system will recognise that parents with learning disabilities and learning difficulties are overrepresented, and that by providing earlier support would reduce the number.
My hope is that by 2030, the family justice system will contribute to the collective care of children and young people, particularly in terms of my work, children and young people who are at risk of harm beyond their family homes, and so will serve as a force through which families can remain together, supported by a collective group of professionals who understand their common duty to create contexts in which parents can safely care for their children.
My hope for the family justice system would be that by 2030, I would like to see more very early problem-solving approaches in pre-birth work. In Swansea, we've used the Born into Care guidelines to really focus on how we support our pre-birth cases. We made changes to our practice that has resulted in a 55% drop in separations at birth. We wrote new practice guidelines for staff based on the recommendations from the Born into Care research. We now allocate unborn cases straight to a social worker. They go to meet the family to find out as much information as possible, Then within 7 to 10 working days, they will hold a multi-agency problem-solving mapping meeting. This is usually around week 11 to 12 of the pregnancy. This helps us understand what we're worried about, what is working well, and what needs to happen.
For me, a family justice system that truly works is one where children and families feel heard, understood, and treated with dignity at every stage. That means meaningful participation, not just being present, being able to genuinely engage with decisions that affect their lives. It also means recognizing the realities that many families face, including poverty, vulnerability, and trauma.
As a mother with experience of being separated from her babies close to birth, I know only too well the pain of this experience. I hope for change in the family justice system so that separation at birth is recognised as a birth trauma. The mother's experience becomes visible, her rights and identity as a mother are held in mind, and she's offered the care and compassion she needs to be able to give her and her baby the best chance of a positive future. I want the family justice system to understand whatever the outcome will always be the baby's mother. The journey doesn't stop at separation.
Thank you very much to everyone who shared their hopes and wishes for the family justice system of 2030. Well, I'm now delighted to introduce our panellists who are going to reflect on everything that we've heard so far. Let me introduce them. To my immediate left is Her Honour Judge Kaptan Supnara, who's a senior circuit judge and the designated family judge for the Central Family Court. It's the biggest family court in the country, am I right?
Yes, overall.
And Jackie Tiotto, who you've already met, the Chief Executive of CAFCAS. John Pearce, past President of the Association of Directors of Children's Services, now a Children's Services Consultant. And Jenny Beck, KC, family lawyer, founder, partner and director of Beck Fitzgerald and also chair of the Nuffield Family Justice Observatory. So firstly, what have been your takeaways from what you've seen so far? Jenny, what stood out for you?
Well, I think the sort of universal agreement from most people across all of that, and a lot of the chat bar as well, that we have a system that doesn't hear children and families well enough, which led me to think, well, we've not got enough mechanisms in place, proper practical mechanisms for hearing children and families. But also, when we do hear children and families, we're not converting that into agency. Even when we do hear their experiences and we understand those lived experiences, we're not turning that into something within the system that actually wraps the system around them. So that's a real takeaway for me. How can we do that? How can we make a system that actually not just listens, hears, but also responds by building an appropriate and better system for them? And how do we then allow that learning to cross our system, which itself is, of course, very disconnected?
I mean, that must be, obviously, Jackie, that was the theme of your keynote. But we talk a lot about not listening to children not being heard. But the gap between saying that sentence and the change, the cultural change that's needed is huge, as I think you tried to point out in your presentation.
I did, and I think we've all got to get behind the culture change that we need to make, which is why I left those questions at the end, really, about, if we really are going to be guided by the kids, then we have to say, how does it feel to you now? And we've heard throughout the webinar so far how it feels, which is that they feel often excluded from the decisions that are about their futures. And to get just that bit right, where they're included, is going to take time. And the child focused courts will be a massive step towards that. But it will take longer to do that well. And I wanted just to put in, I think the Minister mentioned quick. And I think we have to just be careful about quickness not equaling making children feel like they're left with a decision that didn't accommodate what they needed us to think about. And unfortunately, sometimes we need to go slower, and that costs a bit of money.
What stood out for you from what you heard today?
Well, I think the views expressed by the young people was quietly devastating, actually. It reminded me of when I was a very junior barrister and I went along to an event where there were young care leavers and children who were in care proceedings speaking. And they referred to essentially the lack of dignity that was being afforded to them, where they were removed from their homes or constantly changing placements, and all of their belongings were put into black bin bags and symbolically being treated essentially like a piece of rubbish for them, is what was hugely impactful. And I think hearing them here again today, it's a similar message that they are not valued intrinsically, that they don't have a stake, that they don't have agency in processes which place at their heart the children. So clearly we are not getting things right. And young people are, we talk a lot about experts within the family justice system. They're experts in their own experiences and their own feelings and wishes. It's problematic because we have reached a stage where we are looking at the voice of the child, and the family courts historically, not that long ago, had a very paternalistic approach to how we approach children with wardship, etc. And then a whole bundle of different conventions and treaties have led to us incorporating into domestic law the children's rights and the notion that their views are important, that they should be participants in proceedings. There's a huge difference between private law proceedings and public law proceedings. Private law proceedings where children are not parties unless there's an exceptional Rule 16 appointment. And it's sometimes comparable to how adults feel when they are the main witness and victim of a crime and they are placed in criminal proceedings, but they have no agency within that. They are simply a witness for the prosecution. And I think there are parallels there that we can learn from. And at the end of the day, we know, just as adult litigants, that the more participants, the children and families feel heard and involved in the process and decision making, the more likely they are to accept the outcomes, even if they are not ones that they themselves wished for.
John, I want to bring you in. What's your takeaway from what you've heard?
I think building on that sort of cultural change around child's voice and what we mean by child's voice. So, clearly that was very powerful, but we also heard words like active listening and meaningful engagement. And I think for me, the messaging that we give children through the process is really important. So the young person who talked about having to sit in the car park, and actually the sort of both the direct and indirect messaging that we give to children about their importance in the process and their role in the process has to be at the heart of what we really mean when we start talking about child's voice and some of that culture shift that's going to enable us to do that. But I think that messaging is really important across the system, not just in terms of how we message in the context of the child's voice. So it was really encouraging to hear the Minister talk about family justice being at the heart of children's social care. But actually the messaging doesn't line up with that. So, if you look at the Families First Partnership, the rollout, the reforms, all of the activity, family justice is really noticeable by its absence. At the very best, it's at the periphery of the reforms, where actually if we're talking about family justice being at the heart of children's social care, then that has to change. As a Director of Children's Services, I was Director of Children's Services for quite a long time, and family justice, if I'd chosen for it not to be, was never front and centre of my daily work, and was more dependent on leaders within children's services having a personal interest and engagement to step into the space rather than it being a core part of the system. And that messaging has to shift, and we're talking about some of the biggest decisions and the impact of something really fundamental on the life of the child, on the life of parents, but actually it's not front and centre of our children's services system. So it goes back to that messaging that's really important.
I wanted to pick that up because the Minister talked about the importance of family justice, and I wonder whether, because there is a strategy that's being developed, which is, strategies don't solve things overnight, but it is a signal that there's a willingness to consider the reforms in the round, and there might be an opportunity there for for us to galvanise activity together. Do you think, well, Jenny, do you think that's an opportunity?
Well, I think the words well-resourced were mentioned by the Minister, which I found heartening. But I worry that however much we try to shoehorn clever and imaginative ways of hearing children's voices and then turning that into some form of agency within our mini silos across the system, unless we have that proper reimagined, joined up vision that we're all working towards, which could come from a strategy, a well thought through strategy, could be a vision for a better future, but it needs to be resourced. And so I'm heartened to hear that, but I would like to see how that's going to be borne out in actual practice.
It's often said that the family justice system isn't a system, right? It's a collection of agencies. So what needs to shift to make it become more of a system? John, what's your feeling?
So I think that if you look at it as it stands at the moment, you mentioned the 2011 quote about it being a system that doesn't function as a system, and I don't think in the last 15 years that's shifted at all. And if you look at what you would expect to see in the system, a coherent vision, a coherent strategy, foundational building blocks, understanding the evidence, lots of the stuff we've talked about what we mean in terms of child's voice and how it operates as a system, alignment with other bits and other systems, they're just not there at the moment at all. And unless, I think the strategy gives an opportunity to start building from, because I think, in the vacuum that we have at the moment, it's really difficult to see how you build a system. But it won't be, it'll be a starting point. It won't be the be all and end all. And we need to think about, if we're genuine about family justice being a system, what are the component parts of a system? Where do we need to build those component parts, and how do we need to operate, and what does the endpoint look like? And that goes back to what do we want 2030 to be, and how do we want the system to be a system at 2030?
It needs to be braver though, doesn't it? Because at the moment that's the worry, that we have a traumatised system, and changing a traumatised system is really hard because it's backed up against the wall and nobody's got any money. But this needs something brave. It's not going to, a few tweaks isn't going to actually convert this non-system into a system, and I'm worried that it needs a proper overhaul.
And what do you think? I mean, Jackie, you've been in the heart of this system, particularly through a very difficult period with the pandemic and the real restrictions to funding and public funding generally. But can you see that this is a point of change, that there's this opportunity to build a strategy that we can coalesce around?
Look, I think a strategy is a good idea, right? And I think that having some things that we're going to do together for the next 3 years is a great place to be. But I think, to Jenny's point, there is something more fundamental, and I'm probably going completely off script, so forgive me. But I think we have to talk in this country about what family life is. What's the state's role in family life? Because we have at the moment a system that is trying to change, but it also has demand in private law going up again, 7% last year, and that's, for us, that's 4,000 more children. And to think about how to resource this well, so that children are at the centre, so that we work cohesively as a system, I think we have to make it a smaller system. There has to be less in it. And how we do that is very difficult to conceive, but I think the strategy will take us somewhere, but we are going to have to do more, to your point, that just tweaking is not going to be enough. That said, starting a system in private law where you put children's experiences right in front of the judge within 8 weeks of the application is a phenomenal ambition, and it may not be 8 weeks everywhere, but in the worst places it's 12. Well, at the moment, if you're not in a child-focused courts, it might be 59 weeks. So it's still fantastic progress. But I think, rightly so, we're all very passionate about our children and their futures, and it's a very emotive space when you come to court to think about what's going to happen to them, whatever type of proceedings you're in. And to get that right, it requires time, it requires people who have time. Social workers at the moment at CAFCAS have a caseload of 20 cases in the best places, some have more. That might be 40 children, and local authorities the same. So to really get the emotional part of this right, I think we've got to just think about resourcing as well.
And it really speaks to that point about how family justice shouldn't be seen as separate to children and families policy, because a lot of the issues that the court is dealing with is the consequence of wider economic and social policy. So to your point earlier, you know, we need to see a much more joined up approach.
Yeah, completely. And certainly when I was involved with the Association of Directors of Children's Services nationally, we published a paper called Childhood Matters, which was very much about how government could join up the whole range of policy framework strategies that impact on children and their families. And in reality, as you say, family justice, children's social care more broadly, we are dealing with the consequences of the broader society that we have. And to Jackie's point about actually, you know, we have to decide where we step into that space, how we step into that space, and what the state's role in that is. But unless we look at it in the round and understand the drivers that are leading to that increase in demand across the court system, that increase in demand across children's services, we're not going to change the fundamentals, are we?
We won't find those things out unless we start collecting some data.
Yes.
You know, we need to understand. We were talking about a broken system quite a lot, but we can see it's broken. We can see the lists. We can see the dissatisfaction from the young people and the families. But we need to be able to measure it, because until we can measure it, we can't properly work out the fix, can we?
So talking of data, I wanted to share some data now and talk a bit about equity in the system and how equitable our system is. So you'll see on the screen what looks like a very complicated graph, but let me just point out what it's telling us. You know, the left-hand side of this bar chart, you can see that children who are white or mixed heritage in care proceedings are much more likely to end up on a placement for adoption than children who are black or Asian. And at the other end of the bar chart, in the sort of light pink colour, you're much more likely to receive a supervision order if you're black or Asian than if you're white or mixed heritage. Now, this data we published about 3 years ago. It's widely known. We've used Kafka's data, thankfully. Kafka's collected some great data on ethnicity. But what's interesting is there hasn't been much of a debate about it. It's not a topic of discussion. We don't really know why there are such big differences in the orders that are made according to a child's ethnicity. There will be multiple explanations, potential explanations. But I'm interested in why we haven't yet, as a system, really sort of drilled down on some of these questions about fairness and equity. And I wondered if I could ask you about that. You know, where do you think we are in this, as a system, in really confronting the difference that some families are experiencing because of their ethnicity?
Well, the first thing to acknowledge is how welcome the FJO's work is in terms of getting some empirical data to back up what we know sort of anecdotally, but it's important to have that research. And I don't know whether the statistics still demonstrate that children from black and minority ethnic global majority communities are disproportionately represented in, say, care proceedings. But I think this data needs a bit more interrogation. We don't know whether there are cultural issues at play, whether there are wider extended family members in some of these minority ethnic families that tend to step up in order to take care of the children, just because there is a collectivistic approach towards child rearing, whether or not there's a sense of collective shame and honour in terms of stigmatising children within, say, care proceedings, whether or not children have been left at risk for a long time, pre-proceedings. So by the time you get into proceedings, they're no longer of an age that is capable of being adopted. So there are lots of questions that we need to ask. And that sort of intersectionality of approach in the evidence gathering, which will inform how we approach as professionals and experts and judges within the family justice system, it really does need a bit more exploration. Is it, for example, that some of the children from those backgrounds, that they tend to be large sibling groups? Is it a question of trying to find a placement that meets their needs together? because you've got a together and apart assessment that says they're going to suffer by being separated? Is it because they require specific resources? Some of the children coming into my court, particularly for deprivation of liberty orders, they are placed, understandably, for safety purposes, in far-flung regions of the jurisdiction, away from an environment in which when they go out, they don't see anyone that looks like them. There are issues around their dietary needs being met, their religious needs being met, their skin and hair care needs being met. These are all really, really important. And so the system has got to work in a more nuanced way to meet the needs of every family and every child, with all their differences and their personal needs being optimally met. But I do think that this is a discussion that needs to be had, because children, they are the products of their environment. And if this is the kind of experience that families have, what that leads to is an innate mistrust in professionals, in the justice system, which the children pick up on. And therefore it becomes much more difficult to engage in order to assess optimally what their needs are, and then to look at resources that would be applied for that. And there is no question that quite a lot of cases that I hear, you have families from this background that have had previous experiences with state intervention, and state intervention in their country of origin hasn't always been experienced as a benign entity. So that needs to be borne in mind. Concepts of therapeutic input, state intervention for safeguarding and protection, it sometimes takes time for people to appreciate and take that on board. So there are lots of issues that really need to be drilled down into if we are going to really meet the needs of children from that background.
And obviously having better data helps, because
Totally.
it helps to sort of focus our minds.
Yeah.
It doesn't answer all of those questions, so there's a lot more to do. I wonder how ready the system is to have this kind of conversation. Do you feel we're making progress?
I do, and I'm very optimistic about it. And I know that all my fellow judges are really invested in this, interested in it, would be assisted by having a sort of evidence-based approach to the evidence that's presented, a more sensitivity in the handling of these cases. I think we are at a point in society where professionals, experts, the families, the litigants, the court system is able to engage in a constructive discussion about this. But you can't really have that constructive discussion without having a core foundation of reliable empirical data.
Yeah, indeed. I wanted to ask about problem solving, because that came up a few times in the Vox Pops that we heard, and also the minister referenced it and said, we need to learn from the Family Drug and Alcohol Court. What's your sense of where we are with understanding, a shift towards a much more problem-solving approach in proceedings? I'm looking at John.
So I think we understand the evidence base around particular problem-solving approaches well. I think there is a huge question about scaling and resourcing, and how we can operate at scale. I think there is definitely a question about how, going back to that point about the sort of continuum of the system and how it operates, at what point in the process particular problem-solving approaches make most sense. And I think once we're into the court setting, then there's some very good evidence base around a range of problem-solving approaches that can be rolled out. But actually there's a range of interactions with all of the other activity that sits out. And if you think, going back to the point I made before about the reforms, when we talk about approaches around family group conferencing and a whole range of other models that are being rolled out and developed across the system, I think we need to think about the interactions around how that's going to operate. But I think the biggest challenge around problem solving is we know what works on a relatively small scale, but how do you scale and resource and operate that at a much bigger scale to be a core component part of the system?
Yeah. What do you think, Jackie?
I think I want to give a qualified answer, because I think probably I want to talk a bit about private law in respect of problem solving rather than public law and the Family Drug and Alcohol Court, because I think one of the issues we need to debate really is how and whether the court is the right place for families to resolve difficulties, and out of court resolution is one way we can, for some families, offer a different path and a different, perhaps more constructive path. And there are other countries who do this and they do it well. And I don't know how up for that debate we are in this country. We've tried it several times in my time at CAFCAS and we don't really get anywhere. But if we're going to help families to resolve what is right for children when they separate, then it feels better that for families who can do that, that we ought to offer a better solution than we have now. And the families I speak to often say, I don't know what my options are. It's quite difficult when I get into this situation to know where to go first. The websites aren't clear. I have to litigate myself. So I think if we're going to invest in problem solving for private law, when families are trying to organise their arrangements, we have to invest more up front in terms of information.
Well, I mean, look, families break down,
yeah,
and they need help. And of course there must be. The first resort should not be the courts. And if we can have other interventions to assist the families through a time of trauma, then we should look at that. But you're not going to get away from the very high levels of domestic abuse that are perpetrated within families. And I'm afraid there's no easy way of dealing with that pre-proceedings without having a fact-finding hearing, without establishing what has happened in order to be able to assess that risk. And I'm afraid until we address this huge problem in our society of domestic abuse, and its prevalence in this day and age, that it should be at such high levels, until we address that fundamentally, and this goes back to the multi-agency, multidisciplinary approach to all of this, until those fundamental issues that lead to family breakdown are addressed, I'm afraid we are going to have that demand on court resources. And we are overwhelmed by court cases. There's no inkling of them reducing, despite our efforts to try and address the backlog. And a lot of efforts gone in partnership with CAFCAS and the courts in London to try and do that. But we are still faced with ever-increasing numbers of applications, not enough courtrooms. We probably would have enough judges if we pulled in fee-paid judges, but there aren't the courtrooms to be able to deal with those cases. And if we had the resources to be able to reduce the backlog, deal with the cases so that new applications can be dealt with in a more swift way, and the child-focused courts ought to assist with that. I mean, it is a game changer. We don't have child-focused courts yet in London. We're hoping to have them in the near future. But I have had the privilege of seeing one of those child impact assessment reports, and it is extraordinary. The quality, the detail, the front-loading, child at the centre. I got a real 360-degree understanding, I felt, of where the child was at and what the child was expressing directly, not translated and interpreted through professionals, CAFCAS, etc. But the raw communications, I think, the child wanted made known.
Can I just add that I completely agree with all of that, obviously, and you know the Domestic Abuse Commissioner's report reveals the extent of domestic abuse within private law proceedings, and so I don't think there's any suggestion that that can properly be dealt with until we've tackled that particular issue. But for the cases that could be dealt with elsewhere, the difficulty we've got is since legal aid was removed, people just don't know what their choices are. Yeah. So a really simple solution would be to restore early legal advice so that people know what their legal options are. And where domestic abuse isn't an issue with careful screening, other options are available. And that's exactly why mediation and all the other non-court dispute resolution options fell off a cliff when LASPO came in, because people didn't know what their options were, and there's been no sensible in the last 10 years solution, or last 13 years now, solution to that. So bringing that back, and we know that it saves a lot of money because there's data to
There was
prove
a discussion about that, wasn't there, about restoring the green form
the early
legal advice,
yeah.
which then sort of channels people in the right direction, but also leads to early resolution as well, and ultimately, of course, saves money and saves the trauma of going through adversarial court proceedings. But I don't know what came of that. I think with change of personnel and government, etc., it has fallen away. We had anticipated it might come in, but that is absolutely urgently needed. And I know that the former president has made a real case for that, and I'm sure the new president will continue with endeavours to try and get that resurrected. It's something we argued for even when LASPO came in. It was ignored.
And it takes us back to also kind of being where families are, because, you know, separation is a common occurrence in our society. Families are being supported in family hubs and all sorts of government initiatives to support families in the community. We need to join up our system with that system too, so that we know that families are getting signposted support and help with the services that are in the community.
And also we need to find mechanisms to hear children's voices outside of the court environment effectively, because if we're pushing for more non-court dispute resolution where appropriate and safe, then we need to make sure that children's voices are heard within that process as well.
Well, that's a big question about who hears their voices and where they are heard. And for a very long time now, we've felt that actually seeing them at school is a neutral place. It's not a neutral place. That is their safe haven. You know, it's quite obvious if professionals come in and see you and your peers see you being removed, and it's stigmatising and it's embarrassing. So I'm not sure that is the appropriate place. It's a bit like contact handovers. We've gotten used to them being outside a police station for one reason or another. And as I've said earlier, in some communities, you know, state agencies like the police are not experienced historically as benign institutions, and that sort of inculcates fear as well. But in terms of where we see them, I mean, at my court, historically, and we continue at the first hearing dispute resolution appointment, that the children of sufficient age, and now it's about 8 or 9, they attend those hearings. Hopefully with the child-focused courts, we won't need to do that anymore. It has been a very helpful device to be able to get to grips early on with what the child is expressing, because a CAFCAS officer attends and meets with the children. But we do have a room that is sort of child appropriate, but there is no one to look after the child while the parent engages with the court and the court process. And so coming to court, which is the hub of the dispute between the parents, also doesn't sit right with me, but we don't have other resources available. So I think we've got to think very carefully about where the children are seen. In terms of who sees the children, CAFCAS officers are obviously very experienced. When children come to see judges, I mean, there is a sort of well of opinion that says, well, are judges trained specifically to see children and hear them? I think it has worked well to date, but whenever they come in, the first thing we have to say to them is, we can't have any secrets between us, it's all going to be recorded, and I'm going to have to tell your parents everything that you are going to tell me. I mean, that immediately inhibits them. And I wonder whether, even in public law proceedings, when children are used to coming and want to, because they're a little bit older and want to see the judge, and we would always see a child if they want to see us, but I wonder whether we shouldn't utilise the sort of resources that they are adept at. So social media, short form video, recorded in the comfort and privacy of their bedroom, which can then be followed up by them attending in person, because when they come and they want to see me, sometimes they just want to see, and they have every right to see the person that's making the decision about them. They want to see the courtroom where this decision is being made about them. But I wonder whether that video first, because sometimes they come along and they clam up, don't know what to say. If that video were available, I'd have already heard from them directly, and it can be followed up with anything else that they want to say when they visit. So those are sort of simple solutions. That's not going to answer the totality of the difficulties we're in. But it's a start, I think.
And I think with Jackie's presentation, you were challenging us to think about the changes we can all make.
Yeah.
You know, it's something that we all have to adjust.
Yeah.
And, you know, you're thinking about some things the court could do. I'm sure you're also thinking in CAFCAS what changes would be necessary to change this culture to really respond to what children are saying they need from us.
Yeah, and you know, the horse we're backing at the minute is child-focused courts, because that does get us in front of them quickly. But can I just, I know we're short on time, but can I just go back to your data point just for 1 second? Because I think one thing that Aidan and Milo said to me, and I tried to put it in the presentation, don't know how clear it was this sense of how do I cope after the court proceedings are finished? And they really want to know that there are adults in this process who care about whether the decision that was made was right for them, because they all talk about often, you made that decision yesterday, but the consequence for me goes on now forever and nobody revisits it unless I come back to court. And there's something about our data goes nowhere to outcomes for children. And whilst we probably can't resource a system that has judges and social workers visiting after proceedings, we can use data very differently, and we don't, if we were a business, we'd be asking how much we sell and how good the product is, right? But we need to ask what's happening to the kids, because they are the outcome of our work. And so I think that I just wanted to put that back in the mind of the thing we're in.
I couldn't agree more. And I think that whole focus on data to help us see what happens next is so critical. So a final question to you all. What is your wish for the family justice system of 2030?
That it is optimally resourced, that all participants feel heard and seen and valued, and that they have, for my part, confidence and trust in the system and in the judges that are going to be dealing with such traumatising events for their family, and that they have trust and confidence in us to make the best decisions that we can in very difficult circumstances.
Thank you. Jackie?
I think I'd like to make a bid for a kinder system. I think everybody wants to do the right thing for children, including parents, mostly. And it's a very difficult period in everybody's lives. And professionally, everyone that I work with and have worked with for years gets out of bed to do a good job. But the system sometimes isn't kind to itself and each other. And I think we need to work with the emotion that is brought by the children to us and be kind to each other, because that makes it doable.
Thank you. Good thought. John?
Yeah, I would go back to where we started, and a system that is actually a system, I think would be a really big step forward. I think that system being embedded in the broader continuum, both understanding the sort of broader impact of societal impact and effects, but also it really nested within the system, so that actually when children and their families are in the family justice system, it is only there for those who absolutely need to be, and that the broader system is addressing a much wider range of challenges than it is currently. And I think that flows through into impact, and the point that Jackie made at the end there, that we can see the orders that have been made and we can see the disproportionality in that. What we can't see is the impact, and what we don't understand is what does that look like for a child in 5 years' time, in 10 years' time, and actually, of that, what are the positive outcomes that are and what's driving those positive outcomes? And I think at the moment we just have no evidence or understanding of that at all.
Jenny?
Well, they're all brilliant points. I'd agree with a system being a system, a joined up, kind, well-resourced system that takes a child from somewhere and keeps an eye on it throughout its life, or at least throughout its minority, is exactly what we all want. But I don't think we're going to get there in 10 years unless we are braver. And we need to be much braver. And I don't just mean as a system, I mean individually. I mean every single person in this entire system needs to be brave, because we're all part of this change, and as Jackie says, the children's voices are inspiring us to say we actually have to do something about this. So we've got to roll up our sleeves, look at what's broken, not just look down our little lens of what might make our lives easier, but work out how we can stand back and reimagine a system that works and actually put the effort into getting there. And that's tough because building something from scratch isn't too hard, but rebuilding something relies on finding those excellent pockets of practice and actually pushing them out and stretching the boundaries between resources and stuck bits and not stopping when it gets to the too difficult box. So I guess that's my ask, is that we're all a bit braver.
Great note to end on. Thank you so much to my panellists. Brilliant discussion. And thank you to everyone who's contributed to today's webinar, to the young people, the parents, the professionals, and our panellists and speakers. A final question for you before we leave today. Having taken part in today's webinar, how are you feeling about the family justice system now? So that's just come up on your screen. Let us know via Menti. And while you're filling in your answers, I'm delighted to tell you that the Nuffield Family Justice Observatory is launching a new 5-year strategy today. It can be downloaded from our website and there'll be a link in the chat. You're going to find the themes from today's webinar reflected in our plans for the next 5 years. We're going to be focused on building a better family justice system for children and families, ensuring that children, young people and parents have a stronger voice, and working towards a more equitable system, a system that works for everyone, regardless of their race, gender or disability. As our work develops, we would love to involve you and keep you updated. So if you would like to be part of our work, please sign up to our regular bulletin. There'll be a link to that also in the chat, and also at the end of the webinar, there'll be a QR code that you can use. As an observatory, we work with all parts of the family justice system, so we are really keen to hear from you. It helps us learn from your experiences, and it helps us to turn research, collaboration, and new ideas into better experiences for children and young people. So before we finish, let's turn to the question that we asked you. How are you feeling about the family justice system now? Oh, brilliant. Hopeful, optimistic, cautious. Okay, cautiously hopeful. There we go. That's a good combination. Some uncertainty, some feeling the same, some feeling frustrated, but actually a lot more positive, hopeful views than we had at the beginning of the webinar. So I hope we've left you feeling more optimistic about the change that lies ahead. Thank you very much for joining us today. An enormous thank you to all our contributors. We'd love to hear what you thought about today's event. So please, if you have time, fill in our feedback form. We always read them and use them to design future events. So let us know what you think. And we look forward to welcome you to future events. Thank you very much. Goodbye.